Hearing to order. Good morning, everybody. My name is Duff. I will be acting as the chair today since this counselor is a vacant seat. So first, I will read the letter from the governor. Dear councilors, I'm pleased to nominate Edward W. Krippendorf Jr. to the position of Associate Justice of the District Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I'm enclosing the nominee's resume for your convenience. I will start by introducing the councilors who are here. Some may be running late and may join us. Councilor Harold Devaney, Councilor Tara Jacobs, Councilor Paul DiPaolo, and Councilor Terry Kennedy. We will start this with folks you have here to testify on your behalf. The first witness.
Judge Tracy Lyons.
All right. Welcome, Judge Lyons.
Good morning.
Good morning to you.
Chief Justice Lyons.
Chief Justice.
Chief.
Still getting used to that.
That's all right. We like it.
My 5th month, and
Thank you for your service.
well, thank you. It really is a pleasure to be here and see some old faces and to meet some new faces. I have known Attorney Krippendorf for 24 years. He was the lead investigator in the sexual assault unit of the Suffolk County District Attorney's Office, where I was chief of that specialized unit. He handled extremely sensitive cases in a respectful way with victims who were experiencing the worst trauma imaginable. Attorney Krippendorf was diligent in the way he conducted these investigations and worked with a multidisciplinary approach with the victims, witnesses, families, and the police departments at every stage of the case. During that time, he also went to law school and became 303 certified, and actually was the second chair with me on a Superior Court rape case. Even as a student, it's evident he was going to be a talented attorney. After graduating from law school, he became an assistant district attorney in Suffolk County for 8 years and represented clients before me. Actually, the Commonwealth before me. And for the past 11 years as a defense attorney, he often represented defendants who suffered from substance abuse disorders and mental health conditions. Very recently, I presided in the mental health court, actually for the past 14 years. Attorney Krippendorf had a young man who was in my session for 2 years. He referred that young man to our session. I observed directly how he interacted with the family, his client, the probation department, the mental health forensic caseworkers, and the Commonwealth. And he was able to get that young man back on track, and he successfully graduated from the mental health court session. Attorney Krippendorf, he conducts himself with the utmost professionalism at all times. Simply put, he cares. He is a well-rounded candidate, knowledgeable, reliable, and forthright. He treats everyone equally and respectfully, including clerks, staff, probation officers, court officers, and opposing counsel. He has an exceptional courtroom demeanor, prepared, punctual, measured, sound judgment. He is respected by all the judges at the BMC. We are all thrilled and excited for him and the trial court and this well-deserved opportunity to serve the public. The attributes that stand out to me when describing Attorney Krippendorf are fair, solid, steady, compassionate, and hardworking, with a deep understanding of how the community courts of the Commonwealth are the neighborhood courts, focusing on and addressing local problems and offering alternative solutions. If you vote favorably on his behalf, the district court will acquire a wonderful judge who will deliver justice with fairness and dignity. Thank you.
Thank you very much, Your Honor. Councilor Devaney.
Nice to see you. How many years?
17.
And I'm not just saying this. You look the same. What are you doing? No, that was my pleasure. And now you're Chief Justice.
Yes.
Am I part of that now?
Yes. Yes. Yes, you are.
Yeah. Well, it's really an honor that this nominee has you to come. And I'd like to ask you, you mentioned about seen him in many cases. Can you think of one that stands out in your mind about substance abuse or a disability and how he presided?
Yes. In fact, it was last year when I was still sitting in the mental health court session in the Central Division of the Boston Municipal Court. And as I stated, he referred his client to our session. It's a specialized unit. We were the first in the state. 2007, we began the mental health court session in the Boston Municipal Court. And believe it or not, we still have the same probation officer that started this program in 2007 and has continued to this day. So as I stated last year, Attorney Krippendorf came before me with this young man. He suffered from mental health issues and substance abuse. And during that 2-year period, he was hospitalized, but would come back into our session. And Attorney Krippendorf, as I said, works really well collaboratively with everyone, and managed to get his client working with his family. His father came to court every session, the client's father, and we got him back on track, and he successfully graduated the mental health court session. It took 2 years, but I had a firsthand view to see how he handled his case, his client, the family, and how he worked with the team to get that person back on track.
You don't know how much it means to me to have you here and knowing you and that you are, speaking on his behalf. But how many years have you been observing him now, you just said?
24.
Imagine that. We don't get that. And I've said it before, and they're probably sick of me hearing it. We've had people sit in that chair, and I said, well, how many times have you observed this nominee in court? Oh, one time. That's not enough for us. And you're the real deal. And I really appreciate your testimony and for your coming here today. You look great.
Thank you, thank you.
Any other counselors? Mr. Jacobs?
Thank you. I very much appreciate what you shared and how specific it was, and I was just hoping you might elaborate on the hard work element of your observations and experience.
Would you like me to start when he was an investigator in the sexual assault unit and until, I really do have, I guess you'd say, a breadth of knowledge of Attorney Krippendorf. He is and was the type of person that you would want by your side, handling these difficult cases. We handled, as I said, sexual assault cases. Our victims were, teenagers all the way up, I'm trying to think of the oldest, victim that we worked with, in their 60s, 70s years old. And he would investigate these cases, go out into the community, work with the police departments, work with the victims, work with the families. These cases they lasted sometimes for a year or two, but because of the hard work of him maintaining the connections with those people at every stage of the case, we were able to get those cases prosecuted. But without a team, an investigator that you could rely on, and as I also stated, he went to law school during that time, so he was not just an investigator to me. He was, as I said, he was co-counsel with me on a Superior Court rape case, and he talk about the real deal. This gentleman here is the real deal. He's got a well-balanced resume. He was a prosecutor. He's been a defense attorney. He's been an investigator. He really is. I am thrilled for the district court if you vote in his favor. I really am. So.
Anyone else? All right, thank you. Thank you so much, Judge.
Good to see you, Jeff.
Thank you. Thank you.
It's kind of like being the principal of a middle school, huh?
Thank you for your
Yep.
time, too.
Thank you very much.
And our next witness?
Mary Beth Brady.
Shut that door, it just annoys me. Thank you. Woo. It worked.
Good morning, and thank you for the opportunity to be here to
Thank you.
address you on behalf of Edward Krippendorf. I have been hoping for this moment for a long time, and I am so honored that he would choose me to be a witness on his behalf. So I speak from my wonderful experience, personal and professional, with working with and admiring his accomplishments and strength of character throughout the years. In the 20 years that I have known him, there's not one specific quality that makes him stand out in my mind. The combination of all that he brings to the court each day During my 38 years of service to the Massachusetts Trial Court as an assistant clerk in the Suffolk Superior Criminal Court for 25 years, and as the clerk magistrate of the Malden District Court for more than 13 years, I have known Mr. Krippendorf as an investigator of the District Attorney's Office with Chief Justice Lyons, as an assistant district attorney, and as private counsel. In every interaction, he was prepared, professional, and personable, treating each person he encountered with dignity, respect, and compassion. While working with Justice Margot Botsford during the implementation of time standards in Suffolk County, it was a very busy and demanding session. ADA Krippendorf had many complex and difficult cases before us, but he was always fair, ready for trial, open to working towards a reasonable resolution of a case in the interests of justice for the victims and the accused. The experience that he has gained in each of these roles that has given him a thorough perspective of all aspects of the district court jurisdiction, including criminal and civil law, mental health and substance abuse issues, diversity, inclusion, as well as language and cultural differences that impact access to justice in all of our courts. During his impressive career, Edward Krippendorf has earned a wonderful, well-deserved reputation among judges, members of the bar, court personnel, and those who come before the court. He is intelligent, has excellent interpersonal skills, a calm demeanor, and the all-important judicial temperament. The humanity of the work that is done in the district court impacts the lives of those we serve in the most profound ways. I believe that Mr. Krippendorf has touched those lives with empathy in all of the positions that he has held within the judicial system, making each process easier to navigate and less intimidating to understand, especially with his warm wit and sense of humor. In addition to my professional interaction with Ed Krippendorf, I have been a neighbor of his in Braintree and have witnessed his dedication to his wonderful family and commitment to mentoring children in sports and civic activities. He exemplifies leadership qualities, and he and his family go out of their way to assist those around them always. I believe that he has worked his way up through the judicial system and has not forgotten where he came from. His qualifications speak for themselves, and his commitment to public service in every facet of his life and career will make him eminently qualified to take on the challenges of a fast-paced and busy district court. For all of the reasons that I have expressed and more, I believe that Edward Krippendorf is an outstanding candidate for judicial appointment to the Massachusetts District Court, and I thank you for your consideration.
Thank you. That was great testimony. Thank you. Very, very well said. Thank you very much. Councilor Devaney.
I'll yield to my,
Kennedy.
He's cheating bringing you in here. You know that, right?
I'm so honored.
Everybody spent the time for a very, very long time. The former clerk of the Malden District Court,
Wow.
and you missed.
No, well, I appreciate it. And honestly, I have to say, I am grateful that if chosen, he will be going to the district court, because in all of my 38 years of experience, it is for me, the district court is where you really touch people's lives every day. You make a difference. And as clerk, I had the opportunity to set the tone for how I felt people should be treated when they came to the counter in a hearing in the courtroom. And I know that with Mr. Krippendorf, or hopefully his honor, on the bench, he will bring that presence to the courtroom and to the team of clerks and staff, all of my staff. It goes without saying, everywhere he's gone, he just has a gift with people. And that's rare sometimes these days, but I think he will serve the Commonwealth well. And
That's wonderfully said. Thank you. Councilor Devaney. Oh,
Thank you.
sorry, Kennedy.
this is a nice reunion for me. Real, to have two of the people that I so respect and I voted for. So good to see you, and you both look so good. I don't know if I'm going to talk to you later.
me, it's retirement.
I can't believe you're retired. Now, tell me, how many years ago was it that you came here and
2008, and I was 25 years in 1983, I went to the Superior Court, but 2008 as the clerk magistrate.
Wow.
Yeah.
That's amazing. No, I want to thank you both for your service, and I'm so proud to see people that I voted on that have done so well, and we get the feedback to hear how well you've done. So I hope you're enjoying your retirement. Right. Now, I know you've said all these attributes about the nominee. Is there one that you would say that comes out that you think he's going to bring to the court, his best attribute?
I can't think of one, just because, there are so many, and I've seen him in so many different capacities, as DA, as an attorney, and then just, in my personal life. And I just think he just brings he is, as the chief said, the real deal. You get what you see is what you get, and the best is in him. So I think the way, it was always so important to me is how people are treated. Do you feel like, are you approachable? Do you listen? And I think whatever situation, whether it's an adversarial role, he was never an adversary. He was always somebody that you could work with. And
Well, I'm telling you, he's had two great role models, and I know, And it was such a pleasure meeting you, people at Diner, all those good memories. So thank you for coming back. But thank you, your testimony, both of you, means so much, because you know him
Well,
decades. This isn't someone you just, saw a few times in court. So that means a lot to the council, and we thank you.
I told him I'd be more nervous than him, so I mentioned every word was chosen correctly so that you could get a picture of him from my perspective.
It's beautifully done.
Thank you.
Thanks.
Yes, Counselor.
Thank you. I really appreciate what you shared and the history that you have. And I'm hoping you can answer the question, but I wanted to know if you have any experience of how Attorney Krippendorf responds to criticism or pushback, or sort of someone sharing where they feel like something different should be coming from him, like how you've experienced his response to that.
I think he takes everything well. In our very busy session with Justice Botsford, we could be a dynamic duo, but he was always, worked with you, never got upset. He just, and that's an attribute that some people can take things so personally, but, you can take it to heart and maybe change your behavior, but it wasn't personal. And there was never a negative thing to say about him, but just, he could always take it and learn from it. And I think, as all of us, we learn from the mentors in our lives, the people that have helped us to get to where we are. And, it is such an honor to see somebody like this be in this position today, and hope for the best for him.
I appreciate that. Thank you. I'm good.
All right. Thank you very much. Any other witnesses?
No other witness.
Okay, is there anyone else here who'd like to speak in favor? Anyone here who'd like to speak against? Chance. Okay, hearing none, we will open it up to you for your statement, but if you would first like to introduce any of your friends or family here, we'd love to hear who they are.
Thank you. Well, I think the most important person in the room, all due respect to the councilors, is my wife Peggy, who's there. 20, coming up on 21 years. My oldest daughter Maggie, oldest by an hour and a half. My son Eddie. My son Sean, who's 13. And then I have here the Honorable William Galvin, my friend. Joe Eisenstadt, partner. Of course, we know Mary Beth. Her husband Billy is here also. And Judge Lyons, Chief Judge Lyons. Hiding in the corner is my longtime friend Richie DeMeo, who gave me my start in the DA's office. He was our chief investigator there and hired me. Saw something and hired me, and was very encouraging as I went to law school. And then over here we have Sue Connor, who was also a longtime friend from the DA's office. She was our administrative assistant, which is, I think, probably a lesser title than what she deserves, for 30 years there in the office, but kept us all well under control and was so good to all of us there. And then beside her is Elise Hirschon, who's attorney and friend, and here also thankfully supportive. I think that's everybody who's here.
All right, thank you, Councilor Iannello has joined us. So we'll open with your opening statement.
Thank you. I'm going to cheat just a bit, though.
That's all right.
I'm so very pleased to be before you today, and I'm grateful for your time, not only today, but also taking the time over the past 2 weeks to speak with me. I'd like to thank Governor Healy and Lieutenant Governor Driscoll for their trust and confidence in nominating me for this important position as an Associate Justice of the District Court. I'd also like to say thank you to Governor's Legal Counsel, Paige Scott Reed, who I see here, and Deputy Legal Counsel Dara Kesselheim. We also see here for all their time spent throughout the process, as well as Valerie McCarthy and the entire staff who did so much to make this work possible. I also want to say another thank you to Chief Justice Lyons and Mary Beth Brady for their friendship and their kind words here today. I'm happy to have been given the opportunity today to tell you a little bit about myself and why I felt compelled to seek the governor's nomination and what I believe I would bring to the bench should you decide to confirm my nomination. It's impossible to do that, though, without telling you first something a little bit about the most important thing in my life, and that's my family. I grew up the youngest of 3 children to 2 wonderful parents who made it their business to serve their community and their family. Both were incredibly hard workers, deeply religious people, and committed to community service, spending countless hours at church groups, town boards, committees, and community service groups. Growing up, they taught us so many of life's most important and fundamental principles. They taught us to always leave things better than how you found them, always treat others the way that you would want to be treated, and always ask if there's something that you can do to help. They had endless trademark catchphrases to reinforce these principles, such as make yourself useful as well as ornamental, which my sisters and I would often joke about. The reality is, though, that those lessons and principles that our parents drilled into us so often was no joke at all. It had become part of our DNA, part of our daily mission. And something that I noticed to this day is that anytime any of us, my sisters or I, walk into a room, or if we meet someone having a bad day, it's instinctive habit to ask, what can I do to help? In fact, if I had to pick one guiding principle from them, it would be that, help others. On top of that, my parents preached and encouraged hard work and pursuit of education. I worked full-time to pay my own way through college and then again law school. Before and during law school, I worked in the Suffolk County DA's office as a civilian investigator, working out in the community and speaking and working with victims and witnesses to crimes. While in law school, I met my wife, Peggy, who was also working full-time when we went to school. She had been my partner in all things ever since. Through law school and to this day, she not only supports me, but she challenges me, both personally and professionally. Without her, there is no scenario in which I am before you today. As soon as I graduated law school, I began work as a prosecutor in Suffolk County. My time spent prosecuting in the district court was invaluable to me because I was working with a number of extremely busy courts on a wide variety of different types of cases, each with their own individual circumstances. I quickly learned how to assess cases, work with a variety of different attorneys and court personnel, and of course, all of the personalities that came with them. Over the years in the DA's office, the cases I was working on became more complex and more in-depth. The consequence of that was that I spent more and more time with the victims, the witnesses, and even defendants in my cases. My role began to get me more involved in their lives, and doing so, I found that they had as many commonalities as they did differences. For example, I saw defendants that were also victims of crimes at the same time. So victims or witnesses that may also have criminal cases open at the same time. I learned more about their struggles that they faced, such as substance use, housing issues, or prior victimizations that may have made them more vulnerable or may have led them into the position where they were charged with a crime in the first place. As I worked to understand those issues, I became better equipped to work with the court and their attorneys to account for their issues, for example, when considering sentencing recommendations. But I also knew that I had the ability to become more involved in trying to address some of those issues in more meaningful ways if I had the chance. So with that guiding principle in mind, help others, I took a more broad approach to my work. After 8 years, I left a former law firm with Joe and Bill, 2 incredibly skilled attorneys who I've now known for 21 and 27 years respectively, and I now consider them to be part of my family as well. My work as a private practitioner over the past 14 years has been unbelievably satisfying, and I've been able to meet and work with hundreds of clients in need, and I've learned so much just by working with them. The idea of helping others led me to learn different areas of law in order to help my clients. It called on me to commit myself to working with indigent clients so that they would have the same chance at competent representation as those who could afford it. It led me to act as a volunteer attorney of the day in probate court and to volunteer at legal clinics throughout the Norfolk Bar Association. It led me to donate my time as a court conciliator, working with parties at times where they just couldn't seem to resolve their differences. My cases have allowed me to work with many, many clients suffering from major issues that we so often hear about, like mental health and substance use disorders. I've watched and worked with them as they struggle with their conditions. falling time and time again and hoping that someone is there to help them back up. But I've also worked with so many people that are facing other circumstances or hardships where we, or at least I, take so much for granted. Like folks that don't have a consistent or safe place to live, or are victims of abuse themselves, or single parents who are struggling to try and balance a job, childcare, and are still being asked to meet their court obligations. While I hope my legal experience and abilities have helped me to help those clients, truthfully, much of what I have learned and used to help people has come from talking with them and the people around them about their lived experiences and trying to work out ways that the court system can help them. I viewed my role as trying to learn, understand, and then advocate for them. In that role, I've appeared before so many judges all over the state at many different levels. And I've seen, particularly in the district court, the positive impact a judge can have over people's lives and well-being in ways I never could simply as an advocate. And that's what led me to apply to this position. Through all my experiences over the last 20 plus years, I've learned and developed within myself so many things that I believe are critical to being a good district court judge, almost like a recipe of how do you make a good judge. Like the importance of being sure everyone feels that they have been fully heard and understood. The importance of understanding that people are fallible and they make mistakes, but that they deserve our compassion and understanding. But mostly I learned that the district court is fundamentally a community court and should use its ability to involve all available resources simply to help others. I sincerely hope that you'll give me that opportunity, and I'm happy to answer any questions that you may have.
Thank you, sir. Councilor Devaney.
Oh. Nice to see you again.
Good to see you.
You know, I don't have a poker face. I am just so pleased that you applied and that you have been nominated. You're the type of person that we look for, because not only have you had a lot of criminal cases, but you have worked both sides. So you really can identify with the people coming into the court too. You're born with the silver spoon in your mouth. So having said that, I'd like to ask you about how it's changed since you have been aware, how the court has changed. We see a different family, perspective. We see so many things that are coming up before a judge, and we talked about that. I said, 50 years ago, judges didn't have the things that you will face, and tough decisions. But one of the things I wanted to go back to in your criminal cases, there was one, and I remember it. I remember that Revere police officer being killed, and it was first-degree murder. So I can't go through all of the cases, but that I remember, and I'd like you to tell us about that.
Yeah, it was and we talked about it, I think, the other day when we met, but it was obviously a very troubling case. It was a very serious case. It was something, anytime obviously there's a death to somebody, that it involves a lot of serious issues. And there were a lot of complexities to it as well. So it was a case that involved young men were actually charged, but coming through this area where there were these police officers there. They were off-duty police officers, but they had just come from some training, and so still had some of their equipment with them and so forth. And there was an exchange, and one of the men fired and killed one of the police officers. So it obviously had a lot of consequence to it for a variety of different reasons. Had a lot of consequence to the community of Revere, had a lot of consequence to the victims and their family. And it was a long trial, and there was a lot to it. But one thing that I talked about was that I think during the course of that time, because it was a long trial, and I thought sort of spoke to this, is it was a 4 or 5 week trial. And over the course of that time, you're in court with the same people over and over. And of course, we're working with the police officer's family and all the other folks from that community who were there in support of them. But as well, what I started to notice over the course of that time too, was that the individual that was charged, he was there and his family was there. There were a lot of people that were there in support of him as well. And so we would come in over the course of this long trial, back and forth, in and out, Well, his parents were there, and they were there every single day in the front row, and they were there in support of him. And there was a lot, obviously a lot more, you know, you could take that scenario and you could say, this is somebody who shot and killed somebody, you know, end of discussion. But there really was a lot more to it, and there were a lot more of the circumstances, and there was a lot more to him and his family and his background that you started to notice over the course of time. And as you come in, even just coming in and out of the courtroom, those people, and starting to kind of identify that these are people, and at the end of the day, in all the homicide cases that really you deal with, at the end of the day, you know, you're in the courtroom, and you get a mom, and you get a mom in front. And there they are, and there's two different families that are there, and really there's kind of no winners to it. I think that was the other.
One of the things judges didn't have before them 30, 40 years ago is child pornography, and these things too often now. You did have a case. Do you want to talk about that?
I mean, we have handled those types of cases, and obviously they're pretty disturbing, you know, disturbing things to deal with. But, you know, we've handled those types of cases in the past, and
That you, that you, in your, it's, attorney, you had, it was for, let me see. It was with Richard Sweeney and his co-defendant, Robert.
yes, I do remember the case. Yeah, and it was, you know, obviously, again, they're troubling circumstances and they're not things that we, you know, obviously, you know, look well on. However, this was two people that were there, and it was there were two brothers that were both charged. That's why there was a co-counsel in it. And I think, you know, the thing that was important to me in those circumstances is, once again, there are a lot more circumstances to, you know, kind of the person and what it was that brought them to that position where they were charged with that offense to begin with. And in that case, we spent a lot of time, most of the time that we spent was not so much on, you know, can they prove that this happened or not happened, but can we talk about what's going on in the lives of these two people, that brothers, two twin brothers that were charged in connection with it, and try and shed some light on it in terms of what it was that got them to this place. What kind of treatment options can we put into place? What is going to make, you know, the government or the DA in that case feel safe and feel that they're accomplishing their goals, while at the same time trying to make sure that, you know, nobody's victimized and that nobody is, and that this is something that's going to, you know, resolve favorably.
I'm concerned about racial discrimination. Do you see it in court?
Yeah, absolutely. Yeah, I think we see it in lots of different ways. It comes in a lot of forms. We see it in different areas. It can, whether it's in, you know, charging, just, it can start everything from every place from charging decisions. And some of the folks that I represent now, you know, the nature of our job, we get to, you know, we have clients that are family of, you know, very wealthy people. And we also have, you know, I handle a lot of these folks that can't afford attorneys, and indigent folks, or people that we deal with in the clinics. And you do see that it can be community by community, or it can be person by person, but some of the charging decisions can.
And I know, and the councils know it does exist. And we don't have a crystal ball as counselors. We can have someone there that, you know, is pure as the driven snow, and we don't know. And they disappoint us. You know, I saw that, you know, we see the, oh, I don't know, we just saw a little Humphrey girl that was killed by her father. And, you know, and that judge hasn't been responsible for it. And I called Judge Butler because I didn't want him to be on the recall list. He was the one that could have sent her to a loving foster home, but instead he gave it to a vicious father who admitted he was beating her up, and he killed her. And yet he went off scot-free. I'm not letting that go. I'm not letting it go. And he should be, and to give him the benefit after he tried to be on, I can get it personal. But that really concerns me. How about gender? Do you see that? Because that was never in the court 30, 40 years ago. I don't even know if you have something to go by, you know, past history or whatever on these type of things.
Well, I think whether it comes to the racial issues, which I do think exist, and I do think they exist not only with the charger, but also in the court and how the court conducts itself. And I think that it's something that's a troubling thing to see. But I do think that the solution is to be open, from people about what their experiences are and making sure that you're checking yourself to make, be open to listening to, kind of people checking you on it. And I think that with the gender things, we see that coming in as well, and we see lots of people who do come with different gender issues in the court, and a lot more so than at least when I started, which, in a way can be great, because it means that people are comfortable with themselves and are comfortable enough to be, talking about those issues rather than, being too scared or not comfortable in the court. I think the court needs to do everything it can to adapt to that. And, if people come in with issues regarding that, either racial or gender, being open to, hearing from their advocates. And that's something that I think as an attorney was part of my role, is to ensure that I'm informing the court or the clerks or whoever. Here's what's going on here. Here's what we need to try and adapt to. This is, no longer kind of a rigid system, and we need to, be discussing things and talk about ways that we can make sure that the person feels comfortable in being here. Or if, and I think we also talked about, in terms of people that are in custody. I've had folks that are in custody that, one of, our roles, either as an advocate or as a judge, is to make sure that if they're going to be in custody, that they're in a comfortable place. They're where they want to be. They're safe. They're not going to have any issues. So whatever gender they are, or whatever gender they identify as.
The other thing is, I'm very happy that we do have, we have specialty courts. I think it's necessary for drugs, for veterans and everything. What interaction have you had with the special courts?
The specialty courts, I think, are probably one of the most important developments over the past 20 years that I've been practicing. And it started, sort of small with some drug courts, and then it expanded out with the mental health courts and the veterans courts. And there's almost no limit to where you could start to get into some specialty court issues, because I think the value in it is that collaborative approach of spending some time with an individual person, following them through the system, making sure that there are trained people who are there that can talk about the issues, people that are far smarter than me about any of the social services that they need, any mental health services that they need, and the ability to, as a judge, the ability to get everybody gathered together in a room.
In your position in the district court, you can't do all those things, that you really need some specialty court to do that. And I especially like the drug graduations, that people don't know. We do have good programs out there. And these are people who have been addicted for years, decades. And I sit in the back, no one knows who I am, and tears come to my eyes, because these are people that their whole lives was ruined in addiction, and they talk about what the program did for them and how they have been successful. So there's a lot of good things that are going up. I wasn't going to ask you, but Clerk Magistrate had brought it up about time standards. I haven't heard that in years. Tell me, are you with time standards? Where is it in the court system in 2024?
Tell the Chief Justice, but I'm not a huge fan of the time standards. Can be very difficult. Again, because my thinking when it comes to the cases, and this is one of the great benefits to things like the specialty courts, is, when you're talking about drug courts or mental health courts, these are people that a number of times may have setbacks, they may have problems, they may have issues. And one of the benefits is that you're taking the time that you need to not just sort of cut the person off and say, okay, well, you had your chance, now we're going to sentence you. And so I think that time standards, can get in the way of us spending the time that we need to make sure, oftentimes I have people, even if it's not a specialty court situation, this is someone who, before we can really figure out what is best for them or what is best for the system or what makes the most sense, we need to get some evaluations done. We may need to check in with a mental health specialist and have them check for something, or they may have, hospitalizations along the way, or whatever the issues are. Issues come up.
still going on?
There are cases that go on far past the time standards issue.
I agree with you. I agree with you. And I admit my ignorance. I didn't know that it was still going on. So it's still in the court, the time
It's
standard?
in the court, but I would say, I would say also, I remember when they came out and I was in the Superior Court at the time, and it was a very, very, very rigid thing. And I think that what most judges, especially those of us who have dealt with it as practitioners, as we come in, recognize that, you know, parties know what is best for the case. And unless somebody is really complaining about, hey, this person's dragging their feet, or this is a problem I have, you know, there are circumstances when you have to move the case along. And we certainly don't want to have cases that are lingering for forever. You know, there has to be some conclusion to it. But I think that in my experience, the parties know what's best for the case, and the parties,
We've had people sitting here.
Counsel, your time is coming to an end. You,
Good time to know, they voted to time. I'm against time because I think sometimes you need to ask more.
same thing.
And have to answer more. But anyway, I'm done, but I thank you for all the time that
Thank you.
it was wonderful. You're gonna bring the kids, and I'm very pleased. And you have, you know, both sides of the aisle. I couldn't be more pleased.
thank you.
Thank you, Counsel Ionella.
Thank you very much. Just a question on the time standards. No matter what courts, Superior Court, or District Court, the chiefs, if they want to move cases, down the way. Judges sometimes are under pressure to move cases. So it really make a difference with the average case, whether it takes 3 months or 3 years to move a case. It really make a difference.
I want to use up all your time, but my answer is no. I mean, it just doesn't.
Because a lot of times, we talked about this during the lengthy conversation. Lawyers, we have Kennedy for Apollo, Juvenile before that. They have to be in multiple courts a day. So it's tough sometimes, you know, to adhere to the time standards. And for whatever reason, people go on vacation, whatever, case come in. So cases do get continued, and I hope, and I think we talked about it. You're gonna be one of those judges that if it's a legitimate reason that you're gonna agree to continuance.
Yeah, like, again, I think the parties know what's best, and it is, I've certainly asked for plenty of continuances in my day, and I think also, having practiced in the criminal area so much, you know, my clients are not, it's hard to schedule, you know, when they may have an issue. So things come up in your personal life, things come up with other cases and other clients, and you have to have that flexibility to be able to move.
Maybe indicated that you like defendants who are in custody to be safe and comfortable, I think your words. Is that the role of the judge? Can you? I thought it was at the Department of Corrections.
I think it's the role of the judge to make, you know, comfortable, I think in the sense that I think I was answering in the context of, you know, potential gender issues or things like that. But I think it's for sure, it's the role of the judge to make sure that they're going to someplace that's, that they're going to be safe in where they're going. And that and that if they have needs or services or medications, for example, and I think judges do have the ability to make sure that things get communicated to Department. They have to enact it. I mean, Department of Corrections or the Sheriff's Department, it's their role to actually enact that. But I think it's part of, you know, if I'm a judge and I'm going to sentence somebody to a term of commitment, I think I need to be mindful of whether or not it's going to put somebody in danger. And, you know, so at least to make sure that somebody knows it's an issue.
Maybe I'm naive. I didn't realize there was that such a problem. But you practice in Plymouth County.
Yeah, Plymouth County is a majority of place I practiced, yeah.
Right. I get the impression, maybe I'm wrong, that judges that sentence defendants to house of correction or wherever in some unsafe places. Because I've never heard this unsafe until today. Are you suggesting?
I'm not.
The judges, that you know judges who sentence people and wherever they go, whatever facility, that they're unsafe?
I'm not suggesting that at all, and I haven't seen it happen. But what I've I'll be very clear. I've not seen that happen. I haven't had instances where that happened. What I have had, and what I think is important to have the ability to do, is to communicate with the judge and say, I have somebody who has this issue. If they're going to be sentenced, or if they're going to be held pending a trial or something, there's some issue. They have some medication that they need, or they have some special need that needs to be addressed. Can you please make sure that gets put on the minimus? Can you please make sure that gets communicated to the correction center? That's all I'm saying. I'm not, this is, if I gave that impression, that's not the impression.
I don't have any questions. We had a lengthy conversation. We talked about a variety of topics. I like the fact that we're in private practice. You have other people, small law firm, prestigious law firm. I remember David Eisenstadt, what a super guy he was. But when your name comes before the council, I'll be more than happy to vote.
Thank you, Counselor.
Thank you, Counselor. Counselor Kennedy.
I think that's gonna have to do a lot of work with you and Galvin. And I'm not gonna be able to meet any time standards.
He's going to expose us as the true worker.
It's gonna make a lot of money too, I think.
Stop working sometime.
I'm not a big believer in time standards either. I think they're shocking, very. And not enforced across the board. It's just, it's court to court, and they just don't make sense to me. But how about 58 days? Are they overused by prosecutors?
Yes.
How are you gonna
Take all your time, but yes. Sorry to take all your time, but yes, it's a short answer.
I expected you to say that, because that's certainly the case. They seem to be filing them more and more and more. And you know what happens when they file it? Somebody gets locked up. Sometimes they get locked up for a crime that even if they're convicted, they're not gonna get a jail sentence. We're putting people in jail on pre-trial who may never go to jail for that case, but they're in there. And I have a big problem with that. How are you gonna handle it when a prosecutor files a 58A on someone that they're probably not going to jail for anyway? And here we are, the day of the arraignment, you got handed that motion, what are you gonna do? I asked for 3 days.
As the prosecutor, when you ask for three days, I mean, I do think it's something that's, from the time that I started, it was a very rare event, and now I do see it a lot. And one of the problems that I see, I do with it, is that is when they're filed, and then you come back in those 3 days, and I've seen this too much, is you come back in those 3 days, and they have either, the prosecutor is either agreeing that this person shouldn't be held without bail, and they're gonna agree to some conditions, or, the case has changed dramatically. So I think the first thing I'm gonna do
Happens all the time.
is ask a lot of questions about the case and and whether or not this is really what they want to do. And I think you can ask them to have a hearing right there as far as whether or not this is something that's appropriate.
Let me ask you, if you give them the 3 days, why do you gotta lock the person up? They can have the hearing in 3 days.
Or they could have the hearing then. I mean, I think that's what this statute calls for.
What about pretrial conditions? You think they're overused?
I think a number of them are. I think if they're specifically tailored to that case, then I think they're appropriate. But I think trying to get a feeling of comfort out of just making the longer your list of pretrial conditions, I'm not sure that accomplishes what our goals are. Our goals are to make sure that people are safe, or people return to court, or, we have certain set goals. And the length of that list shouldn't be done over the quality of the list. And so whether it's, GPS, which is used an awful lot, having that very specifically tailored, or if used at all.
Some judges will put somebody on a GPS, there's no exclusion.
Yep.
So any that doing that?
I've had that happen. And, and even still, I think the other issue is the more of those conditions that you have, somebody has to monitor those conditions. And if there's a violation of those conditions, what's your reaction to that? Is it an instant, having somebody placed into custody, or is there some further exploration of why there was a violation of that condition or not? And I favor the second, which is, not to kind of jump to any conclusions about, okay, that number 4 on your conditions have been violated, so that's it.
A lot of times, I know you know this, a lot of times as a defense lawyer, when somebody files that motion, you're almost forced into stipulating the dangerousness, because if you let them put a witness on the stand, you just preserve the testimony that can convict your client later. So you're sitting there and you say, all right, we'll stipulate. And then what you're arguing about is those conditions, what they should be. And they can be pretty intrusive on people's lives. They can affect their jobs. They can affect their relationships with their families, all kinds of things that I personally think they're way overused everywhere right now. And you're sitting, Judge Krippendorf sitting there. Terry Kennedy's there with the prosecutor just filed the motion on his client, Joe Ferrara standing there. And we don't want him held for 3 days. We don't want to preserve the testimony. So, all right, we'll agree he's dangerous. Even if we don't really agree that he's dangerous, we're going to do that. Now the prosecutor's giving you this whole list of conditions they're looking for. And I'm saying, how about just a stay away, Judge? What's Judge Krippendorf going to do in that situation?
I think if the facts and circumstances dictate that just a stay away is appropriate and it's going to keep people safe and make sure that, you know, there's not a issue of danger, I'm fine with that.
We've obviously sat down a couple of times prior to sitting here today. We've talked a lot. I have to vote for you so that my phone stops ringing. With people calling me, telling me what a great guy you are, and I go, yeah, I know. And from everywhere. I got a text yesterday from Brian Merrick. Judge Merrick, we all like a lot. You know, it was a very touchy-feely message, and we know what a touchy-feely person he is. But I've gotten a lot of phone calls.
Funny.
A lot of them, more than I have probably certainly a lot more than I got on Galvin. So I'll be voting for you next week. You're gonna be a terrific judge.
Thank you, Counselor. Counselor DiPaolo.
Thank you, Counselor. Morning.
Good morning.
Could you share your thoughts on raising the age of juvenile jurisdiction?
I think that the court has done a very good job at recognizing the issues with the juvenile mind. I am in favor of it. I've been in favor of, I've had instances where it's been an issue for young folks. One is, I know I spoke to a couple people about a client that I had very early on, who was 17 years old at the time that she was charged with a very, very serious offense, also involved in a shooting. She had really just turned 17, in fact. I think she turned 17, I think in October, and this incident happened in November. And this was in 2011, or 12, that it happened. It involved an armed robbery, it involved a shooting. She was with 2 other people. She was, you know, the getaway driver, but was charged just the same as everybody else. So was charged with some very, very, very serious offenses. Had she done that 2 years later, she would have been a juvenile. But because she did it at that time, she was charged as an adult. She ended up going to state prison as a 17-year-old girl. She spent a number of years there. I remain in touch with her. She got out. She finished all of her probation. She is either just or has graduated. I'm not sure when the graduation is, but we spoke recently. She's graduating college. She has a job. She's doing fantastic. However, for lots of people, that may not be the case. And she was treated as an adult, and luckily she came through with lots of family support. And, you know, we worked with her on probation afterwards. But I'm mindful of the fact that this was a very young girl who was charged with a very serious offense. And it seems arbitrary to me that had that same set of facts, same thing happened 2 years later, she would have been a juvenile and she would have no record. You know, she would have no criminal conviction for a felony. And I think that happens a lot. And I think that, you know, the SJC in this state has done a lot of good work at examining it, listening to the experts. They're the ones who know a lot more about the brain than we do. And a lot of those efforts, and, you know, I've read the materials, and they, again, I think relying on the experts is probably the better course of action than just coming up with this arbitrary date and saying that's the date that now you're an adult. being mindful of that and being mindful of I'm sorry.
No, please go ahead.
I think I was going on you, but
I appreciate what you're saying. Please continue.
I think being mindful of that is important. Just like every other condition that we're mindful of when we're thinking about sentencing and when we're thinking about charging decisions and things like that, the age should be no different. And I think, the emerging adult issue is a real live one and one that's being dealt with.
For me, some of these issues connect to safety, and in a totally different context, you can talk, well, not necessarily totally different, but you're talking about unsafe. Be mindful of sending someone to an unsafe situation. There was a recent case in Superior Court where a student presenting with some severe mental health challenges was ordered back to her public school in spite of overwhelming evidence that she was not equipped to succeed there. And on top of it, that it really wasn't a safe place for her. Not because of the people in the building, but because of what she was walking in with. And to the judge's credit, after in a conference, the Globe quoted the judge saying, "It's not as if I'm sending her to a dangerous place." And there was a incident when the girl returned to school, and to the judge's credit, the order was reversed. But to me, it speaks to a notion of, that's an incredible case of bias, where the bias was, this is tough love for this child who needs to be in school. And my experience in school was XYZ, and that's going to be this child. It's what's in the best interest of the child. And I'm wondering, if as a judge, you're able to, you've written extensively in your application that this is your mindset, but how aware are you of your biases? How have you ever caught yourself checking your bias in a situation like that, or perhaps totally different?
Yeah, certainly I've not always made the right decisions, and I think that's one of the things that I think, and I know the judge, I know that case you're talking about, and I thought the fact that she, recognized it, was able to kind of, not dig heels in to say, sorry, that's a decision I made.
And I have tremendous respect for that. Yeah. Happened.
And I think, at the time, probably thought that she was doing the best that she could for that person. I think, I've certainly identified ways, the longer I've been, particularly the longer I've been out into private practice, and the more people I've dealt with in different contexts, whether they be with, some of the mental health issues or, the drug issues and things like that folks have had from the time that I was a prosecutor, or even, folks that have housing issues. The time that I was a prosecutor, the more time I spend with them, I can see that there were areas where, maybe I didn't make the right decision, even as a prosecutor, or in the beginning stages of when I've been out representing people, would sort of put them into a category of almost a similar mindset of, I know what's best, and I think I know what's right, and this has been my experience with something, so I don't understand what the big deal is. But the more time that I've spent with some of those people, and their families, and some of the collaterals that really are sometimes the most help.
Sure.
The interest, I don't know, it's an odd situation, but there was, the one that I think about is on a fairly recent basis is maybe a year or 2 years ago. And this was an indigent client that I was helping in Brockton, and he was from Haiti. And so there was an interpreter that was there with us helping out. And he was talking about, and he had some mental health issues at the same time, but he was talking about some things that really just seemed odd to me. I thought it was sort of part of his mental health. And so I sort of discounted some of the things he was talking about, because he was talking about, that his wife had dolls about him and things like that. And it just didn't make sense to me. And I sort of discounted it. And as we were leaving, the interpreter said, "Hey, listen, this is part of their religion. This is part of what this is a real thing for him. And that's what that's how he grew up. And this is a real sect of what they believe in. And, that's not part of, some of the things that he misunderstood." And it was a good checking for me, I thought, to say, okay, this is not, this is something that he believes. It's part of his religion. And that is something I have to take into account. And I think I was too quick in that circumstance to sort of lump it in with everything else. It also gave me a lot, it gave me a lot more consideration for, that's one more person that we can rely on to help us to understand other people's cultures and other people's backgrounds and religions. Sometimes even just the interpreter can help you to talk about what what people grew up, how they grew up, or how they grew up in their country when they come here and things like that. I think having those types of experiences and at least recognize them, stopping and say, okay, that was a little bit quick on that. And I think she's right. And, I'm not sure really why I went there. And I think it's important for judges too, to have that and not be, I think the most important thing that we can do, whether it's an attorney or a judge or any of us, is to not be defensive about that type of a thing. And if somebody says, hey, I think you're missing this, to be open to hearing it and not sort of take it as a criticism, no matter how they deliver it. But
Thank you. I'll jump around real quick before I'm done, because a lot of my colleagues have hit important issues. Councilor Devaney brought up race in our courts. And the Gantt study at this point, I would say, is kind of dated. The data in it is dated. I'm wondering, and in that study, it was really focused on sentencing, and a lot of the sentencing disparities were in Superior Court for a million reasons. But in your role, and I'll jump on something Councilor Kennedy was talking about, like 58As, for example, are they disproportionately given to defendants of color?
one thing I liked about the Gantz report was that nobody can really deny the statistic. When you're talking about numbers and you're talking about statistics, it is what it is. And so it's hard to really argue about that too much when you're dealing with conclusions.
Are statistics being gathered adequately, in your opinion, to make sure that we're on top of this issue?
I think that I have seen a lot more work done today than I did even 5 years or 10 years ago. I mean, in very recent years, and I can recall spending time when I was even in the BMC, where there would be folks in there collecting data on big issues of bail. Was one big one is 58As, and I understand that's a big issue because it's an on-off switch. You're in custody or you're not. But even just bails, I mean, because you can have a 58A where somebody is being held without bail, but with a lot of folks, a $1,000 bail is the same net effect, meaning there's no chance in the world that they're going to make that. So I think gathering that data is important, and because it also sort of holds that mirror up to the court to say, hey, listen, maybe this is not what you intend, or this is not what you think you're doing, but it is something that is happening. It's the result of what's happening. So you need to be a little bit more careful about this and make sure that that's not part of the calculus. So does it happen? I believe that it does. Is it intentional? I don't know that it's an intentional thing. I think it's something that, we all constantly have to grapple with and constantly have to recheck and make sure that, somebody's telling us when we think that we're off. But I do see them gathering information. I think it's helpful. I think for all judges, it's helpful to know what, they may not remember day to day. You handle so many cases and so many things come through. And I don't think we can expect them day to day to remember everything they do, but to say, this is kind of your trend and this needs to be addressed.
I'll just note that as a student, I spent a summer overlapping with your time in the DA's office. We never interacted because I was in different divisions, but I appreciated my time there. So I thank you for your service in that role. 209As. Have you had occasion professionally to interact with 209As?
I have on both sides, but I've represented people on both sides of them.
It's all anecdotal, of course, right? In my world, people I talk to, they say one thing that they think was a little awry sometimes is judges taking too much into account regarding the impact on the alleged perpetrator in 209As. Occasions where, the person's work will be impacted. And so we're going to go we're not going to put in an order to protect the victim. Right. I'm wondering what your it's a very difficult balance. I'm wondering your take.
I think it is. I think as with lots of areas that they deal with, it is a difficult balance because I think you're balancing lots of different interests. In all these cases, the 209As are no different. I think anecdotally speaking, I think an issue I have is when enough time is spent discussing, either having the hearing or, sort of just, listen, someone was charged, so we're just going to issue an order, period and end, without considering everything. But, I think that's not part of what you're supposed to be considering is what the effect is on them. For a reason, that's not part of that's not part of what the 209, there's a purpose in the 209A order. It's for safety, it's to protect people and,
If we were gonna err, would you say you'd err on the side of safety?
yeah, I think that's the motive is to make sure that somebody is safe. That's the whole purpose in having them. So if somebody's reasonably in fear, then that order should issue, irrespective of, their police officer or whatever, however it's going to affect them, or their job. They can't do their job. People have found ways around it. So
Well, thank you for your time and I appreciate your thought
Thank you.
on these issues. Thank you.
Thank you, Counselor. Counselor Jacobs.
Sorry. Hi, good to see you again. We had a really great conversation, covered a lot of areas, and as the room has taken their turns, a lot of the areas I was going to bring up have already been addressed. I think one of the few areas that we talked about that I have a lot of interest in that hasn't come up is around the area of gender bias in the courts, both from the standpoint of attorney wellness, so hearing from women attorneys practicing in court, appearing in court, who have a wide range of stories around sort of categorizing their tone or lack of respect, things like that. And the other side, and I'm sure there's multiple elements we could talk about, but the other one that comes up a lot in conversations I've been having are around the sense that court is not necessarily a safe space for victims of domestic violence or sexual assault, or in other ways, people who've already experienced trauma, where court can add another layer of trauma particularly through interactions with judges who may marginalize their experience or again, categorize their experience as something minimal and sometimes because it's a traumatizing experience, the articulation of what happened isn't always as clear necessarily, or articulated in a way that lands for the judge. So it's sort of a brush away of like, that doesn't sound so bad. All of that to say, I'm interested in hearing your thoughts about your perception of gender equity in the courts and what you could bring in your role as a district court judge to affect some positive cultural changes there, norms.
thank you for the question. I know we discussed, and I think one of the biggest things that I always have in my head is my wife, as you know, is an attorney, and we came up together and we were prosecutors at the same time in two different offices, but she's a pretty impressive attorney in her own right. And so we talk a lot and we know a lot of the same people, in the different courts, and my experiences as a prosecutor, my experiences as an attorney and hers. And so I'm very I don't want to say firsthand because it's really her firsthand, but I'm very familiar with, the differences in how sometimes we treated for doing the same thing, acting the same way, particularly when we're prosecuting the same argument or prosecuting the same case. And, we talk about it. And I think it's something to be aware of. It's something to try and be mindful of when you're dealing with people. Again, we can all, we all have experiences where we have, maybe misstepped or, maybe not been as mindful about something as we could be or should be, or out of a place of just not understanding something or not understanding that something's an issue, having done something that's either offensive to the person or is taken the wrong way. That's why I think the most important thing is that people feel comfortable in saying, hey, that's not a great way to address this person, or that's did you notice that that person, was tough and that person was nasty and that was really, that's the only difference. Being open to that and mindful of it and okay, and saying, okay, I see that, is important. But it's something that at least I've lived with over the past 20 years, having two of us going through a lot of those same processes at the same time. And I think it's recognized by lots of other people. The report that I think shed a lot of light, a lot of people, myself included, when you read through it, and there's so many different areas that it covers that frankly, we just hadn't thought about maybe. Whether it be how you're addressing people or how you feel or how they're dressed, in court and things like that. Small, subtle things that can either make somebody feel more comfortable or can make somebody feel like they're stepping onto an alien planet. And, do their best work when they're in court and they're feeling comfortable. People who come in as witnesses or victims are being the most effective when they feel comfortable and when they feel like someone's going to listen to them, or they feel like there's been some accommodation made for them. Again, that's where I think that part of my role as an advocate for them, to alert somebody, alert the clerk, alert the court officers, alert the judge. Hey, this witness is coming in. This is their issue. Is there someplace I can, because this is not a great place to have trouble. I can recall a case where actually I was the defense attorney, and there was a victim who came in who just had a massive teddy bear with the hood up, and was just holding the bear and had the hood up, and he asked me if there was an issue with it. And I don't think that's not the issue. She's coming in to say her piece, and so she's going to say her piece. I think it's then incumbent on a judge to make sure that they're expressing themselves as being approachable, so that those advocates, in my role, one of the harder things that I would have to deal with is from judge to judge. Can I talk to them? Can I approach them? Are they going to be okay if I go to sidebar and say, hey, listen, I have this client who had a traumatic brain injury and is prone to outbursts or comes across this way, but don't misinterpret that. I have a judge that will take me at sidebar, will listen to it and say, okay, we'll make those accommodations. Or some judges just are not really open to it. They don't feel approachable. They don't feel like there's somebody that you can have that kind of not legal conversation with. So to the extent that you can make the court someplace that is not just a, kind of a meat grinder of just this case comes in, we're going to do this, we're going to do this, we're going to do this, and then move out. Something that's more a place where people can come in and there may be things to discuss first to make sure that things get set up in the right way or make accommodations. And some of the accommodations we can make now, and we could talk to the courts about, some of the technological things that we've been able to do. For folks with disabilities or, that may not be comfortable in the courtroom or whatever it is. That years ago, I can remember were the 1 in a million, where you may videotape somebody or have somebody remote. The whole process to set up, people didn't want to do it and made things hard. And now I think the technology has just allowed us to be much more accommodating and be comfortable. So
I appreciate all that you said, and you touched on one of the other areas that I'm particularly interested in hearing touch on so just a little more about. That's around the area of people with, whether it's TBIs or cognitive delays, developmental executive function type delays, or otherwise struggle with participating in proceedings, processing language or decision making or comprehension or what have you. And I have heard frustration about a lack of accommodations and sensitivity around that, but I'm curious to hear your thoughts further.
well, I mean, I'm sensitive to it. I've experienced it, personally, not myself, but with family members. But it also, I think that where we can sometimes run into a problem in the court system is that there's a bit of a gap between someone who is not, we have a legal standard, someone who's not competent to stand, not responsible, and there are legal standards. And then there's, folks like you and I that may not have any issues whatsoever. There's a lot of people in between that don't meet the burden of being not competent to stand trial, but have a lot of difficulty with understanding the process, or may need to have things explained more. Or, due to some traumatic brain injury, something that happened suddenly in their life, or something that they were born with, just different in some way that they're in that middle gap. And that it's not something that would stop the process like a competency issue. It's something that should slow the process and allow us to take the time to make sure that we're managing them, be sure that they're being treated fairly, reasonably, and are being heard. I think the most important thing to come out of any court experience on either side, whether you're a defense attorney or a prosecutor, whether you're the victim or the defendant, or whoever you are that's coming in there, the most important thing when you walk out the double doors at the back is that you have felt that you were heard in the experience. And if you are having trouble communicating that, you think either I didn't get the time, or they couldn't understand what's going on, or I didn't understand what they were saying, that affects that feeling when you leave. So I think that addressing that middle gap of folks that are just maybe aren't at that place, but they are also, they need something more than I might. And again, I think that's someplace where, to the extent that the courts, clerks, the judge sort of sets the tone for how that court's going to be. Right? But to the extent that that clerk or the court officers or everybody that's participating in that, those that people can come and talk to them, or they can be approached and not just sort of say, well, there's nothing we can do about it. Think about, is there some option? If there is some option, can we make that work? Because oftentimes they're very small adjustments that we need to make. There's nothing that's going to require you to tear down the courthouse and rebuild it in a different way. It could be very simple things, allowing somebody some minor accommodation that may be as simple as, and I think we talked about one instance, a stress ball. If they want to have a stress ball while they're testifying, why should that make any difference? It doesn't. But it makes them feel more comfortable. It makes them be able to get through that process better. It makes them be able to, their story, as you say, clearer. I think that's all important for that part of that process.
Appreciate that. I don't have any further questions. I'm good.
Thank you. Counselor Hearin.
Thank you, Madam Chairwoman. Nice to talk to you again. We had a nice conversation a couple of times, I think. We met in person. I appreciate that very much. You have an outstanding reputation, despite Judge Galvin.
He's taking a hit today.
Ask Judge Galvin to leave.
Galvin's been a big advocate, as well as Councilor Kennedy. Marty Healy grabbed me at the MBA awards dinner and talked to me about you. Matt McDonough called me yesterday. Brian Merrick reached out to me. So many people, and no negative things. I know my colleague over here asked you about maybe not enough restraining orders issuing, and I have the opposite concern. I was a cop for 30 years, and I do appreciate your service very much as a DA. And I was in court yesterday where my guy got hemmed up with a restraining order, an extension that should have never, ever issued. And the judge extended it for another year because she said that's 20 years ago something happened. Nothing's happened since. No altercation, no argument, nothing. He was a good dad that took his daughter's cell phone away. They weren't living together. And kid went home and said, Mom, my dad took my cell phone away. And she went to court and said, hey, I'm afraid of him. 20 years ago something happened. And literally, based on that, he got a restraining order. And then yesterday we went to court and I thought, geez, for sure, nothing's happened in the last year. Nothing, no violations. They're sharing custody of the kid. He's actually had full custody of the kid for 2 years, 14 years old. He sees that she's doing bad things on her cell phone. He grabs her cell phone. The judge yesterday extends the order again for another year. Takes his guns. You know what he does for a living? He does security. He represents a company that they protect celebrities and things like that. He can't work for 2 years. We're doing contracting stuff and other things. But I'm telling you, I've seen it over and over again where I think judges go the other way and they're overprotective. I mean, nothing's happened in 20 years. The guy's had guns for 20 years. What's your experience?
I think that I have had, as I said, I've represented folks on both sides, but so I've represented people that are defending themselves with the restraining orders and also plaintiffs who are coming. I think that they're some of the harder things that judges have to balance. And, I think we all have I've had experiences just like that. I know Attorney Hearin, and I spoke about one recently, similar experience, where the evidence just didn't really match up with what was being claimed. And, I've practiced in family law as well, and I've seen instances where, they are being used to gain some advantage in the process. And those are all, and I think what's unfortunate about that is that they diminish, there are a lot of people that need them. I've also worked with a lot of people that need them and they need them bad, and it's the only thing that keeps them safe. Not only keeps them safe physically, but also gives them a sense of feeling safe about their daily lives. And so I think in those instances that you're talking about, which I have to acknowledge because I've worked with those types of cases before too. In those cases, I think what's most troubling to me about that is in instances where they're being misused is that they really diminish the value and they diminish, they diminish the use of folks that really need them and who are using them properly or who are asking for them under circumstances that they really need them. So I think that though you're touching on an area that is very difficult to balance for any judge. And I think the most important thing the judge can do is and hopefully this happened in your case, but in my experience, the most important thing that they can do for us is to give us as much time as we need to flesh out all the different issues. And the time that I've really felt the worst about those cases or cases like what you're talking about are ones where there's been a very quick judgment about it's been applied for and I'm going to issue it. Or there's been, a very quick judgment about it happens both ways. I think that anytime there's not a lot of discussion about it or people aren't permitted to bring in their witnesses or to whatever it is they're going to do, that really diminishes the judge's ability to make a good or the best decision they can. And I don't know that any judge, if they were testifying under oath, would tell you that they've made the right decision in every single one of those cases, because it's very difficult to do.
Yeah, it was just very frustrating. I mean, at the end of it all, my client said, geez, Judge, this is not justice. I mean, like, tell me what I did wrong, and he'll go to the appeals court. It's going to cost him a ton of money. And I'm pretty sure it will get flipped, but it shouldn't come down to that. And we brought out that she's in public housing. She needed the kid to live with her or she was going to get thrown out. It was just a total miscarriage of justice, and I'm very disappointed. And I hope you're not going to be that judge.
I hope so too.
Pregnant pause.
Other than that, all right, I'm done blowing off Steve from yesterday. Bad for my client.
Still in his questions, man.
Yeah, but other than that, like I said earlier, I think you've done a whole lot in just over 20 years. Highly respected. You've done a great job on both sides of the aisle. You have great advocates, and I'm going to vote for you next week. So thank you.
Did you have another question?
Thank you. I just wanted to say that I got a call from Father Baspus, and he was with regards diocese who has asked us to vote for this outstanding nominee. The other thing is, with your permission, I'd just like to say, I agree with Councilor Ferrara about restraining orders 20 years, but it's very sensitive to me because that's why I ran. Because I had a friend who was seeking a restraining order, and she had gone the 8th time to court. And so this time we had a friend, a police officer, go with her because he was getting more abusive. Her boyfriend was getting more abusive, and she feared. And so the police officer went before the judge and said she fears for her life. Give him a $400,000 bail. I gave him $400 bail. Turned to my friend in fear, paid it. My friend was dead. And you know what that judge said to her? He said, you have been wasting my time and you've been wasting the court's time. And that's why it's very important, as my colleague said, about restraining orders. And they have to know that they are real and act on them. And, when our police officer friend said she's fearing for her life, and then he said that, and I didn't know governor's council. I didn't know how the judges got their jobs, I'll tell you. My husband's a firefighter. Our friends were police officers, firefighters. I didn't know. And when I found out, I said, there'll never be a judge like that if I get elected. So I looked at the duties of the governor's council, I said, I can do that, and that's how I did it. So that's why it's very important to me when I'm even bringing up 209As, they are important. And they have to be, I worried, Councilor Duff, I really worried through the pandemic, because I thought some of the courts were on the phone. How can you see someone's body language when they've been accused?
Counselor, do you have anything to?
So I'm sorry, I'm going on, and I just wanted to mention Father Basper, so that's, thank you.
Thank you. That was interesting. Thank you for your application. We've spoken several times and we've covered all the issues today. It will be my pleasure to put your name into nomination when we meet again with the Lieutenant Governor. That said, this hearing is closed.
Madam Chairwoman.